This week on The Sceptic, I speak to Fred de Fossard, Director of Strategy at the Prosperity Institute, on why reform is right to plan to scrap the Equality Act.
It is quite clear that the Equality Act has created a very pernicious culture, which I believe to be discriminatory, and has enabled a huge ecosystem of jobs, of promotion hierarchies, of opportunities, which are offered basically against white men in the public sector and increasingly in areas of the private sector.
And Dr Tilak Doshi, the Daily Sceptic's energy editor, on how net zero is sending Germany's chemicals industry down the drain.
Germany was an undisputed powerhouse in the chemicals industry. It remained as a leader until the period when it started adopting its green policies. Germany's industrial decline, there's no end in sight.
Hello and welcome to episode 69 of The Sceptic, the Daily Sceptic's weekly podcast. I'm your host, Laurie Wastell, an associate editor at the Daily Sceptic. Now, if the Equality Act 2010 made discrimination illegal, then why have we seen the rise of persistent and widespread discrimination against white males across the public and private sectors? Well, to discuss that today, I'm very pleased to be joined once again on The Sceptic by Fred de Fossard, who is Director of Strategy at the Prosperity Institute. Welcome, Fred.
Hello, Laurie. Thank you for having me back.
Very good to have you here, Fred. So lots of details to go through on this law today, but let's just introduce what's happened first. So last week, Reform pledged to repeal the Equality Act, and this has caused quite a lot of debate. Most notably, it prompted Keir Starmer to himself wade in and declare that this proposal was shocking and it was against basic values in his estimation, and even indeed that perhaps wanting to repeal it was un-British in some way. So, well, what do you make of that to begin with, this attempt to present this particular bit of equalities legislation as, some sort of central feature of our constitution, almost as if it's akin to Magna Carta?
It's a great question. It's a funny statement from the Prime Minister to say repealing a 16-year-old law would be un-British, particularly a law which was implemented largely at the behest of the European Union as well. So we're taking, the laws recognising the EU's fundamental charter as now being fundamentally British, which I think is an interesting and eccentric position. But of course, anti-discrimination law didn't begin in 2010. The Equality Act brought together particular pieces of European law, as I mentioned, but it also is the bringing together of a few decades of anti-discrimination law. So I can see why a Labour politician would be opposed to its repeal. The Equality Act is definitely a fundamental ideological law of their own. You say it's being treated in a constitutional way. And if you think about the Labour psyche, it is kind of constitutional. Anti-discrimination, anti-racism, all these things are completely central to their identity. So I'm not surprised they've reacted with such hostility, but also they shouldn't be surprised that there has been a growing and very legitimate objection to the way the Equality Act functions. It's been a pretty much consensus talking point on the British right for 5 years, maybe more now, to be sceptical about the Equality Act, be sceptical about some of its worst elements, like the public sector equality duty. I think the leader of the Conservative Party, Kemi Badenoch, when she was a minister, I think she was an equality minister at one point, was criticising the way the duty operated and said the Equality Act went from being a shield against discrimination and is now behaving like a sword of discrimination just against different groups. Reform, unsurprisingly, being a bit more radical, maybe a little bit more first principles and what they want to do by saying they want to repeal it very quickly after getting into office. It opens up a really exciting area of debate because this is the Equality Act has been responsible for many problematic policy decisions, positive action, the public sector equality duty, the very, very infamous RAF anti-white male discrimination case. Of course, what happened in the RAF was found to be illegal. I think they overstepped the legal line by saying they don't need to promote any more stupid white male pilots. The Equality Act does outlaw discrimination of that kind. But what defenders of the Equality Act miss is that positive action, the public sector equality duty, have interesting cultural effects which are slightly different to necessarily a legal thing. You can't judge a law or a policy just through the lens of litigation. You have to look at the cultural effect of what it's created. And what it has created and has enabled a huge ecosystem of jobs, of promotion hierarchies, of opportunities, which are offered basically against white men in the public sector and increasingly in areas of the private sector. And clearly the RAF overstepped the mark by explicitly saying they weren't going to promote white male fighter pilots. But other parts of the public sector, which have been well documented, whether it's the BBC offering internships and graduate programs to ethnic minority candidates only, whether it is the massive rise in minority interest staff network groups in the public sector, which have almost taken on the role of a quasi-internal trade union representing minority ethnic interests. It is quite clear that the Equality Act has created a very pernicious culture, which I believe to be discriminatory, even if some aspects of the letters of the law say otherwise.
Quite, Fred. And I think a key point is that it is often quite vague. I mean, it says you're not allowed to discriminate in terms of positive discrimination, but the key provision is the public sector equality duty, and that's that bodies must make efforts to improve representation of underrepresented groups. Now, this is never put in a very clear statistical way, but so what does it mean, do you think, for these kinds of diversity bureaucracies? Because it seems to me that they all have some sense of what this means roughly, and at the end of the day it broadly equates to them trying to reduce their proportions of whites and men, although there are sort of different ways that they, and sort of wheezes that they can find out and use to do that.
Yeah, that's very true. I mean, it's often likened to affirmative action in the United States, which came in since the 1960s. And where it's different is it's not quite so explicit as affirmative action. But the point is it is tapping into similar themes, which is about using policy today to make right the wrongs or perceived wrongs of the past regarding minorities, or whether it's cultural or ethnic or gender lines along the lines of protected characteristics as defined by the Act. And ultimately, the output of that is a discriminatory culture. It might not necessarily be explicit, but it is implicit. And also there's an interesting ratchet effect at play. So in 2017, the Equality Act was amended to impose gender pay gap reporting requirements on all businesses of 250 employees or more. You will note that the Conservative Party was in government in 2017, of course, so they actually made the Equality Act stronger rather than weakening it. So it is something for its MPs and former ministers to bear in mind when they complain about the effect of the Equality Act. And reporting requirements are a very interesting tool because, of course, they begin as optional, but then the reporting becomes compulsory. And then the threat of quotas or greater incentives to narrow the gaps or to change the gaps, they use the threats to force the policy outcome. There was a similar policy which was being mooted by the Financial Conduct Authority a couple of years ago. The FCA regulates financial services in Britain. The FCA, as a public body, has to follow the public sector equality duty, like all public sector bodies do. And what they decided to do is they decided to prepare a policy on diversity-related hiring reporting requirements in the financial services sector. So this is not about their own hiring policies as the quango that the FCA is, but is it about FCA regulated firms? And the document they published suggested that all companies regulated by the FCA, so this could be small finance businesses with a handful of employees going up to large banks, would have to produce for the FCA reports on their diversity hiring initiatives. And this is a really interesting example of how they would use a reporting requirement to ultimately nudge towards a greater equality-driven approach to hiring. And they would use the threat of making it mandatory to basically force them or encourage companies to do this anyway. This policy has not actually been implemented. There was a campaign against it. Prosperity Institute, the think tank I work at, was one of the organizations that did campaign against it, highlighting the fact that it's a very eccentric interpretation of the public sector equality duty applied to the private sector, which I think is insane. And I think it's insane for a quango to try and impose that on a private sector organizations. But it's the reminder of the kind of thing that they try to do and how equality law is used as a ratchet like this to engineer vast levels of social change. This is not an anti-discrimination law. It is something much greater than that.
And just to go into a little bit more detail on that particular question, because, well, of course, it's the public sector equality duty, but there are at least two mechanisms, as well as the ones that you've just pointed to there, that make this really transfer itself over to the private sector. The first is the key one, really, that if private sector firms want to do contracts in the public sector, then a lot of them, which a lot of them do, then it applies. And I suppose there's another way that this is pushed in there is through ESG requirements, which is, for instance, that if a firm wants to do an initial public offering on the London Stock Exchange, then they will have to have various diversity requirements, including a certain number of women or minorities on their boards and things. So, I mean, this is not just applying to the public sector, is it?
That's completely correct. It's really interesting to dig into it this way, and you see how the public sector, private sector, corporate world kind of work in tandem or in symbiosis when it comes to matters of diversity. The listings requirements imposed by the stock exchange, which is a private business, onto other companies floating on the LSE are extraordinary. And it is one of the things which is making people think twice about listing in London. I'm not saying that equality mandates for board representation are the only reason why listings have declined in London. But when you are making the decision of where to list, and there are many, many factors at play, this becomes a potential deterrent that entrepreneurs and their investors will start thinking about and whether it's worth the bother. It's really intriguing how the public sector and the private sector almost encourage each other to go down this route. There have been situations now where large investors will impose these kind of obligations, environmental or diversity related ones, on companies they invest in. So we have this strange situation where the ideology of the public sector has started to capture the corporate world, which then filters down to smaller areas of business. And ESG is probably the most pernicious and high profile example of it. Also, ESG is a very intriguing beast when ESG scores are taken into account. Companies that might lose ESG ratings on matters of environmental policy can gain ESG ratings by turbocharging on the social and governance aspects of ESG, which often means greater levels of diversity or pegging pay of their executives related to diversity matters. So it's really interesting how it's got its claws into so many areas of the economy without necessarily. This was not planned. It's almost happened relatively accidentally, or for many people feel like they've woken up in a new world where this agenda is really calling the shots.
And another way that the equality has affected the functioning of the free market has been in its equal pay for work of so-called equal value provisions. And now, as people will know, I mean, I think one of the classic recent example where this has manifested itself, it has been in Birmingham Council, in which it was found that it could not pay significantly more bonuses to binmen than to secretarial staff and others in the main, because these jobs were ruled to have been of equal value in some rather arbitrary way. And this is an extraordinary way for pay rates to be set, essentially, and very anti-market.
It's hugely anti-market. These are really interesting cases. The Equality Act has made them worse, but some of these equal pay cases did predate the existence of the Equality Act. So I think the Birmingham one is a really good one to talk about, and then I'll mention the supermarket ones as well. So you mentioned the binmen in Birmingham. It was decided that thanks to the way Birmingham Council assesses the value of its different employee types and different jobs and the pay banding structure they had, that workers who worked indoors and were more likely to be women, like cleaners, and workers who worked outdoors were more likely to be men, like binmen and grave diggers in particular, were doing jobs of equal value. So the council itself, I think, did lots and lots of analysis and reviews, and they determined that these jobs were actually of equal value. And then it was found that the greater pay and bonuses offered to binmen was discriminatory. The issue we have here is that's partly public sector pay banding policy. I think the public sector does not make its own case the public sector often makes a rod for its own back on this one because of its own internal policies, which have now shown to be very expensive errors in light of this. But it doesn't take into account the actual reality of what a labour market looks like and what it is like trying to employ people to do particular jobs, and the inducements that an employer can offer to get people to do particular jobs. Working outside in the early hours in the winter is a hard and unpleasant job in many cases. Throwing bags of refuse into bin lorries is often quite unpleasant. We don't really need to explain how unpleasant it is digging graves. If these jobs are very hard to hire for and the labour market is very strained, it makes perfect sense to try and offer bonuses to get more people to do those jobs. And in taking into account the greater level of physical strain that those jobs require, unsurprisingly, they're more likely to be male. I do not think that was a case of sex discrimination, but the law says otherwise. But I did say earlier, I think some of the way the public sector determines the value of its own jobs almost allowed some of these discriminatory claims to be brought. The Supreme Court certainly didn't help, though. In 2012, they backdated, they expanded the deadline by which claimants can make backdated claims, which increased the liabilities massively. And that is what ultimately tipped the council over into bankruptcy, because it now cannot afford to pay back the claims. For claims dating to perhaps say a 6 months each, it might have been more affordable, but they were able to claim for many, many years of discrimination, which is what has led to the explosion. So that is an interesting area where the decisions of court has made things worse. When it comes to Next and Asda and other, I think, retail companies that have the distinction between warehouse workers and cashier workers, I think the law is much more absurd, because I do actually think the supermarkets are working in a much more competitive jobs market. People do change jobs frequently if they are concerned about, if they feel like they can get an hourly rate better elsewhere. And yet, the Next case, when you read the judgment and you read some of the evidence submitted, shows a really, really absurd philosophy that it's now up to judges to set wages, which is completely mental if you're a private sector company. Some of the evidence submitted in the Next case suggested that there was a gender-based taint to retail work that was more likely to be undertaken by women, and therefore it was paid less. Despite the fact Next provided loads of evidence to show that some of the non-salary inducements to women working in their shops, but also men working in their shops, was a budget per person to buy clothes from the range. Because of course, if you hire people to sell clothes in your shop, you'd like them to be wearing your best clothes. And then it's a really, really quite insane situation now where the supermarkets and the retailers like Next, who were providing ample evidence of the genuine labour market factors which led to them offering different salaries for different jobs. This is not a man being paid more than a woman to do the same job. They are men being paid more than women to do different jobs. But of course, it's not all men and women. I think the warehouse workforce in Next, it's about 55, maybe 60% male, 40% female, 45% female, so not overwhelmingly male. And the cashier jobs were maybe 60% female compared to 40% male. So it wasn't a case of really, really overt, outright, straightforward sex discrimination either. It was really a private business paying within the labour market it operates in. And yet so far, judges at the Employment Tribunal do not see it that way. It seems that the equal pay for equal value law has become a very, very strange beast, where it means judges can set wages, which is an insane environment for a business to operate in.
So we've detailed some of the effects of the changes that the Equality Act has brought in, but I think it's important also to tackle this at its philosophical root for a second, because of course, in what we've just discussed, roughly the complaint is that there is a given disparity in pay, or that one job is, say, 65% male and only 35% female or something like this. And those things are very likely to be seen by many on the left, and increasingly in our courts as in themselves evidence of some kind of discrimination, some kind of unfairness. And this obviously is what the public sector equality duty is trying to address as well, which is that, where there is underrepresentation, so-called, that is supposedly evidence of unfairness, and therefore that you have to try and change that. And so on the other hand, there is a more sort of straightforward liberal view, which would just say, well, we need employers not to discriminate against individuals, but that's all. And then let the social outcomes and the employment outcomes be as they may. We don't take a view on that as a state. But we've really slipped quite far in coming to this understanding and this view almost as a society that any given disparity is necessarily evidence of discrimination.
Yeah, I completely agree with that. If we can return somehow to the liberal position you describe, I think that would be much better. As I said earlier, though, equal pay law did not begin with the Equality Act. It has many, many decades of history. And the roots of the equal pay for equal value stuff does go back to the 1970s. Your listeners may well have seen films like Made in Dagenham about discrimination claims brought at the Ford plant by women. So these things do have a long history, and I do think advocates for abolishing or repealing the Equality Act should tread with a certain level of care, because I don't think that there is ever going to be political consensus for no discrimination law at all. Indeed, I don't think there are many countries around the world, I think it's fewer than 5, and they're not particularly brilliant countries worth emulating, that have no forms of anti-discrimination law, particularly when it comes to workplace and pay discrimination. I do think this is a very interesting policy challenge, and it's an important place to try and get to, because some people have said before that we can and should just rely on common law and contract law protections against discrimination. Sadly, I don't think those protections exist or could be magicked out of anywhere, I think, and nor do I think it's politically viable to go to a world in which there is no form of anti-discrimination legislation. We may have to properly look into repealing and reworking a form of equal pay for equal value with a much more sensible definition. It might be about ensuring that there is no discrimination between the sexes and maybe other kinds of protected characteristics, or whether we change the term from protected characteristics to something else, maybe a personal characteristic which reflects something immutable about an individual, and ensure that there aren't pay differentials based on those characteristics, particularly if they're doing the same job as one another. But we need to get to a situation where market reality is able to be reflected by companies again. And the worst thing is that many of these laws get worse and more onerous the larger a company gets. So the incentive to grow a business is removed. We are creating a labour market quite like France is, actually, where with the new Employment Rights Act, which has just come into force, France, for example, has a huge number of new labour market restrictions imposed on businesses, like compulsory union representation when a company hits 50 employees. So guess what? There's lots and lots of businesses with 49 employees in France, and then very, very few with 50. The Employment Rights Act will have similar effects and similar brutal cliff edges and disincentives to growth along similar lines, but particularly when it comes to equality law. Things like equality action plans, I think, may well be implemented following the Employment Rights Act, which will mandate employers to introduce new plans to deliver equality. So just as you said, any disparity of outcome or performance or pay or imbalance between the workforce may well be seen to be unequal as a result of discrimination, not unequal as a result of, say, the local labour market, or the skill set of people available, or the demands of the particular jobs and the kind of people that might like to do that particular job. The fundamentals of choice and people having different preferences has gone out the window.
So all these are important issues, and it's interesting that Reform are now looking to tackle them and broaden its policy appeal, perhaps. So what did you make of that announcement last week, Fred?
So Reform's announcement last week was very interesting. Obviously, to wrap up these points about the Equality Act, I said it was a relatively brave thing to announce, because it's been greeted with a huge amount of really aggressive criticism from the government, who clearly believes that they will be able to make political hay with this. So it's incumbent on parties like Reform, who want to repeal the Equality Act, to make a really, really convincing and clear argument about what they want to go, where they want to go to next, and why repealing it would actually be better off for a greater mass of British people. But it's very important when you think about the actions of a government, because the Equality Act is one of the laws which really, really put sand in the gears of normal democratic governance. Quite like the Human Rights Act, quite like the Climate Change Act, it is a huge vector for judicial review, and is a huge way in which ordinary policy making gets bogged down by bureaucratic difficulty and the threat of judicial review. For example, it was completely insane that the appointment of Dido Harding to run Test and Trace in 2020 was found illegal because the health secretary at the time did not follow the public sector equality duty by making a direct award to give that woman that appointment, which was an emergency appointment made in the start of the pandemic. If the judicial review new architecture around the Equality Act is able to lead to appointments like that being deemed illegal, you can see why a government that wants to do quite radical things, particularly with civil service reform and basically reshaping the state and reshaping the economy, will need to do things like looking at the Equality Act and particularly getting rid of the public sector equality duty and positive action, which are the really have the most pernicious effects in the governance of the country. But to the wider shadow cabinet announcement, it's a sign that Reform are now not just in the business of making policy announcements, it's about building a team. I think it is very clear that Reform takes seriously the attacks on them that they are a one-man band, that they need to develop a bigger policy program, and that they need to be able to show that it is not just Nigel Farage and some of his loyalist allies like Richard Tice, that there's a bigger, wider and very compelling political program to go with it. But as ever, defections come with at risk. People will say this is diluting the party's identity. And I think this is the tightrope that all political parties have to walk, but particularly a political party which is coming in from the more insurgent side of politics into the mainstream. In Britain's electoral system, you need to get, if you're a right-wing party, 35% of the vote, maybe ideally 40 to win a majority in the House of Commons. This current government was able to win a majority on 33%, which was extraordinary, but it has faltered very brutally because the votes on the right and on the left were divided in every which way, and Labour MPs snuck through to election, many of whom had very, very small majorities. You've got Labour MPs representing basically right-wing seats. When you add up the Conservative and Reform vote share in many Labour seats, let's think about lots of Labour MPs representing seats in Kent, for example, they have far greater number of of Conservative and Reform voters than there are Labour voters. So this is the peril of winning a large majority on a small vote share. So this is a really interesting dynamic at play with first past the post. The efficiency of Reform's vote is very useful, but I really do think they need to try and get over 35% and towards 40. And as part of that, that means you need to have a hegemonic appeal in your area of the political spectrum. So that's the right. They really, really do need to have a hegemonic appeal on the right. And if they don't get that, then they will be undermined in the way that the Conservative Party was undermined from the right by Reform and previously UKIP. And then they need to work out how to build more towards the centre to go from 30, 32, 33 up to 37, 38, 39, 40. And I think the defection strategy is part of that. But it'll be very interesting to see how can they broaden their appeal further while maintaining the integrity of their identity. And that's what the recent development of Restore UK is so interesting for, because the big test will be, does it represent a shift from the Reform grassroots to something to its right?
So let's get into that a little bit then. I mean, it's interesting, in fact, on the day we're recording this, we're talking about the Equality Act proposal from last week, but also there's been another seemingly well thought through proposal today, which is in various immigration policies announced by Zia Youssef, the new Shadow Home Secretary from Dover. And there's various things, but this includes a new deportation command. It includes a new bill to make sure that all immigration cases would be made non-justiciable, so in the gift of the minister only rather than the courts, and then various other things as well. And there was a key line I thought that was very interesting from the press conference, actually, from Zia Youssef, which was he was accepting very frankly that this would be a really difficult task, and that previous governments indeed had failed to do this, and failed to put their money where their mouth is, in particular because they didn't have this policy completely worked out from day one. And so that is what Reform is really trying very hard to do, and that they are sort of increasing the size of their policy department and so on. And I thought actually that showed an impressive level of seriousness that so far I don't think you have actually seen it in Restore, for instance.
It's a very fair point. I think Zia is totally right about the challenge and the necessity of thinking these through. Let's take the deportation policy that they announced. So they're talking about the necessity of a deportation command. I don't know whether that's going to replace border force or immigration enforcement, which currently works to the Home Office, but they clearly want to give it a sense of mission. One thing that needs to happen, of course, therefore, is looking at human rights law. People who have studied human rights case law relating to immigration in the last 15 years may well know that a huge number of immigration removal facilities and detention facilities that the Home Office and Border Force run before deporting people that have no right to be here have been shut down. And they've been shut down thanks to human rights related judicial reviews. And it's a really interesting example of the way in which lawfare has damaged our ability to enforce our own borders. The Manston Barracks scandal from a few years ago is again a really interesting one, where human rights claims brought by people representing refugees or asylum seekers who were kept there led to the closure of the facility. Now, of course, the facility did seem to be in quite bad condition, but that should be a solvable issue. But it's a reminder that without going after the fundamental laws around human rights, it's going to be very, very difficult for any kind of deportation policy to take place. But I'm sure Reform are very aware of that. Regarding justiciability, this is highly related to that. I think that it's very important that people who have an immigration decision or an asylum decision declined by the Home Office have a certain level of right to appeal. I'm not sure if that appeal should go straight to the courts. I think ultimately we should have a situation where the final authority of whether someone comes into the country, either as a legal migrant or as an asylum seeker, rests with the Home Secretary, who is accountable to Parliament. Restoring these decisions to a more political and democratic territory, I think would be better. I think it would be more predictable, and it would align incentives and accountability much better. I do think that would be able to provide a form of due process because, of course, Home Secretaries do not operate in a vacuum. They represent elected governments. They are likely elected MPs themselves, and therefore I think it is legitimate for someone in that position to be able to make the final decision, provided the quality of evidence at their hand is good. I do not think it would be the abolition of due process. I think what we have right now with thousands of pages of immigration law, which judges and lawyers in the immigration courts, I don't think even know what they're judging on and practicing on half the time. The system we have right now does not work and is not working for British taxpayers, for British people, and nor does actually the system work for people going through it, who often just sit there waiting for decisions that never come. Sometimes they just hope to wait out the government and disappear and abscond into the country. But also it does treat the people who have more legitimate claims quite badly because it is so dysfunctional. So I think it's an encouraging announcement, but as ever, the proof of the pudding is in the eating, and there's going to be a huge amount of detailed work required.
And finally, just to get onto Restore itself then, so how significant do you think that is? And I suppose one point to make might be that, well, many of the criticisms that Rupert Lowe previously had made of Farage and Reform under Farage were things like that it was a one-man band, things that it was all talk and no policy, and that it wasn't particularly serious about governing and didn't really understand the task at hand. But I mean, Reform have been quite successful in the past 18 months in broadening what they're doing, in fielding lots of candidates for the local elections last year and winning them, and this year too, looking likely to do well, and sort of many other institutional buildings that it's been quite successful at, as well as the policy we've been discussing. I mean, could Rupert Lowe's own previous criticisms of Reform not now rather apply to his own vehicle?
I mean, look, it's a very fair point. I think that, it's a bit of a wild card political party at the moment. I've been trying to work out how much of the attention and excitement about it online is an organic expression of right-wing discontent with the state of reform, how much of it might be driven by Elon Musk's enthusiasm for Rupert Lowe, leading to particular levels of algorithmic excitement online, how much of the attention is coming from Americans. It is always understandable for a right-wing insurgent politician to have people on his right demanding someone to go further and faster. I think you see that, and actually you see that on the left as well. This is the political spectrum is wide in both ends, and people representing a right-wing banner will always have people further to their right, sometimes keeping them honest, sometimes reminding them of their principles and where they've come from, but also sometimes demanding they go to ideological positions which are unviable or unpopular with the public and also won't work. I'm not going to comment on whether the quality of Restore's policy development at this stage. They have just launched as an organisation, and it is very much around the personality and preferences of Rupert, who is a very devoted MP. I mean, we just need to see what happens. Obviously, I think they found it too late to be able to stand candidates at the local elections. So maybe we will have to keep an eye on what kind of defections there might be within Reform's ranks. Are people going to start resigning their membership? I mean, Reform published their membership ticker, which by all accounts is very accurate. So you could check whether that changes or it slows down or even declines. But let's see. I mean, my hunch is that the criticisms of Reform around things like name recognition are correct. And name recognition and almost celebrity status is vital for cut-through and success in British politics. And Nigel Farage is by far and away the most recognisable politician in the country. That is not to do down the depth of Reform's appeal. It's not necessarily a one-man band at this point now, particularly when it's been polling so consistently strongly for such a long time. But also the party itself is quite anxious to develop its appeal beyond its leader, Farage. Let's see if there are any defections at the more prominent level to restore UK. I think for the time being, we will have it will be what it is, which is a largely online pressure group function. It might do some useful things, pushing some ideological buttons in some ways, and if it does attract disaffected members and voters from Reform, then that's going to be very interesting. In our first past the post system, like I mentioned, small parties gaining can wreak havoc on their immediate rivals by taking voters away in tightly contested four-way split elections. So let's see if that happens there. It would be worth considering whether some of the announcements today from Reform around things like Christian heritage could be considered a response to Restore, but who knows?
Well, I know Prosperity Institute is non-party aligned, and that was a very diplomatic answer there, Fred. But I suppose finally, just in a word, should Farage be worried?
I think on balance, no. I think that he needs to hold course and maintain speed and think what are the most important issues facing the British people. It is the state of the economy and immigration and the health service. Obviously, Reform hasn't talked about the health service much, but if you look at things through the prism of immigration, the economy, and the health service, that is probably the best way to get the largest number of British people on board with an interesting right-wing agenda.
Fred de Fossard, thank you very much for coming on The Sceptic.
Thank you very much, Laurie.
Now, Germany has long been the engine of the European economy. So what does it mean now that because of net zero, its key industry of chemicals is going down the drain? Well, to discuss that, I'm very pleased to be joined once again by Dr Tilak Doshi, who is the Daily Sceptic's energy editor. Welcome, Tilak.
Thank you. Good morning, Laurie.
Yeah, very good to have you here, Tilak. So we know that the energy costs associated with net zero are posing problems for countries and companies around the world, but perhaps nowhere more so than in Germany and its chemicals industry. And that really is quite significant, given the place of Germany as this central industrial powerhouse within Europe, or at least historically. So what's happening to Germany's chemicals industry, and how significant is that for the bloc of the European Union as a whole?
Yes, I think anyone familiar with the Industrial Revolution in Europe would sort of be aware that it wasn't just machine tools and combustion engines that were central to the Industrial Revolution, but the chemical processes, the chemical industry was very much the spine of Germany's industrial emergence. It was way ahead of both Britain and the US in terms of breakthroughs in industrial dyes, chemicals, pharmaceuticals, fertilizers, ammonia, and so on and so forth. So Germany was an undisputed powerhouse in the chemicals industry, a global leader. From 1870 to 1914, very much so. And it remained as a leader in the global chemical industry until the period when it started adopting its green policies. In 2010, the energy went transition led to a situation where power prices were very high, famously shut down their nuclear power industry, stopped themselves from exploiting both oil and gas, and Germany's industrial decline.
That's the end of the free part of the podcast. If you'd like to listen to the bonus interview, you'll need to become a regular donor to the Daily Sceptic. For as little as £5 a month, not only will you be able to watch or listen to the whole podcast, you'll also be able to access articles behind our paywall and join our discussion forum on Discord, where you'll have an opportunity to discuss the latest content on the Daily Sceptic with other donors, members of the editorial team, and some of your favourite contributors. Once you've become a donor, log in to the Daily Sceptic using the same email, and you'll find a link to the premium version of the podcast on the homepage, including instructions about how to listen to it on your favourite podcasting app. Remember, you can access all this bonus content for as little as £5 a month. Just go to dailysceptic.org/donate.